like you, be strong to hold the powers of the sun. To dream, believe.
Let's listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I'm your host, Pavarotti. I'm here to discuss the Idaho 4 case. And I've got two videos coming out for you today. One of them, as promised, is going to be a head knocker. This one I wanted to get out because it's just an important one for me to get out. I've got some information that I'm going to show you here in just a few minutes that will answer some of your questions, if not all of your questions, about those 68 terabytes of discovery that's been given to the defense. It was clearly explained what that discovery consists of in one of the hearings. So when I heard that, I recorded it and I want to share it with you because I know everybody has a lot of questions about what the heck could all that, all those terabytes be. Well, they told us. But before I do that, I just wanted to talk about this because there's so many morons covering the Idaho 4 case. Not just morons like mainstream media, morons on, YouTube, but, well, I mean, these morons, I guess, would be on YouTube. But even the ones that are supposed to be really smart, the attorneys that cover the Idaho 4 case. I listened to them. Some of them are just ridiculous. And other ones that are even really good. I mean, I'm not saying these are bad attorneys. I'm just saying they don't follow close enough on the case. Now, Andrew Myers is different. I like Andrew Myers. He does follow it close, and he actually is able to look at it in a non-attorney way a lot of times and pick up on, things about the case. But most of the other attorneys can't do it. I mean, even ones that I like, Andrea Burkhart, I think she's probably an excellent attorney, very smart lady. But I try to listen to her coverage like as she was listening to the hearing the other day. And I had to turn her off pretty quick because she doesn't have the ability to look at things objectively and pick up facts that she should be picking up. Because as an attorney, because she does it a lot, she looks at everything based on the argument. So her mind, instead of picking up on, facts, her mind goes to, well, this is this type of argument and it's all about the argument, and she misses all the facts. But I'm saying she misses all the facts. She misses most of them, enough to where I had to turn it off and go, well, you're not gathering anything. You're just looking at it straight from an argument perspective. So with all that being said, I was watching one yesterday, and I'm sure the guy's smart, probably is a great attorney. But he says the most ridiculous things I've ever heard, and it's kind of stuff people will hear and they'll start running with it. I've already heard two other moron content creators run with his words. Ridiculous. And I'm going to point it out because, that's what I do is I point out ridiculousness, and I'm going to point out why it's ridiculous, how it's ridiculous, and give you a receipt on how ridiculous it is. So let me show you.
You may recall several weeks ago after the motions hearing in the Bryan Kohberger matter, I said, I believe that behind the scenes, the defense is going into mitigation mode and they're trying to cut a deal. And that deal would probably include pleading guilty to all 4 counts in the Bryan Kohberger case, as well as the burglary count. In exchange, the state would drop the death penalty. Now you may say, Scott, what has changed your mind about that now? Well, first, we know that there are a couple of things. We know, obviously, Bryan Kohberger is the suspect in the quadruple murder for the University of Idaho students, right? And we know that he has a trial coming up this spring and summer. And we know that the judge has denied many and is going to deny more motions against the defense. And so now the defense, things are getting serious. They either have to start seriously going into trial preparation mode, and they also are in the mode of trying to cut a deal. What is the deal? Usually in death penalty cases, it's saved my client's life. That's what the goal is. Yes, you would love to win the case, but that is a big table that you have to run to get there. Very, very difficult because the evidence is usually pretty significant if the state feels they are going to go with the death penalty. And so how do we know that that could be taking place? Well, we know for a couple of reasons. And the first one is, obviously, first reason is that what I just mentioned, things are getting serious now. But second, there is a protective order. And a protective order is an agreement or an order by the court saying very limited people, and it normally involves the attorneys on both sides and any investigators or professionals engaged in the case on both sides, gets to have access to certain things, and that they cannot disseminate that information to any party that's not directly involved in the case. So the protective order says you must not reveal this information. If you do, you can be subject to contempt. And what do we know? The judge unsealed a protective order in this particular case. Even though it was originally sealed, the judge basically said that there's no compelling basis to keep this protective order in and of itself sealed. Now understand, the contents of the records of the protective order are going to remain confidential, and that's fine. But what we do know is these are mental health records that were initially handed over on January 9th of this year, almost 2 months after Judge Stephen Hippler ruled that Bryan Kohberger can face the death penalty. So why would the defense be turning that over? Once again, mitigation. Here's all the reasons. Look at my client's mental health history. Here's issues maybe family has had. Something's not wired right. Somebody's broken. Please consider this. Take the death penalty off the table. Or the second reason is defense experts are going to rely upon this, and they have to turn this information over to the prosecution because it forms the basis of their opinion, whether it's for the defense case in chief or ultimately for mitigation if it gets to sentencing. I do believe it is for mitigation purposes. We'll have to wait and see. Like I've said in the past, I've only done one death penalty case, and frankly, we got them to take death off the table. So it can be done, but it's a mitigation mode. You're saying, spare my client's life. You can't get a death penalty because of all this mitigation. So let's just cut to the chase. Either take it off the table completely or let us plead guilty to the charges and take the death penalty off the case. This is why it's so important for the courts to disclose this information. I understand there's a reason to keep certain records private, but we should know, the world should know what is taking place, and then we can figure out what it actually means, which is going on in the case.
What did I tell you? I said when the judge unsealed that protective order about the fact that the defense had disclosed mental health and medical records for Kohberger and his family, that guilters, because he didn't release what those records said, just the fact that he unsealed the fact that there were records and they were going to keep them private. It had no reason to be unsealed, just to show people that, there's stuff about mental health that you can't see because that lets people just run wild. Well, here's another one that's running wild. Well, let me tell you that he should know this, okay, because he is an attorney, and he even mentioned the mitigation several times there. But in a death penalty case, you have two different things that you have to do as defense attorneys. You have a guilt phase, and then if found guilty, you immediately go into mitigation. So during the process of preparing for trial, you have to prepare everything for mitigation. So in the chance that your client is found guilty, you're already prepared with your mitigation investigation to present to the judge and the jury of why the sentence should be not as harsh as it should be. Part of the mitigation is doing a family history of mental and health records, including that of the defendant. That is something that's required for the mitigation phase. Now, you just heard that moron say that he thinks that the defense is trying to cut a deal to get the death penalty removed by Kohberger pleading guilty because they turned over the mental health records of Kohberger and his family on January 9th. And that's a clear sign that they're trying to cut a deal. moron. You see, if you actually followed the case and you actually paid attention to things, then you would know that the reason they turned that over on January 9th is because that was the deadline that the judge had set for the defense to turn over all of their discovery, including the discovery for mitigation, which would include his health records. They turned it over on that date because they had to. It was the date the judge gave them to do it. Let me show you. Okay, so this is the schedule of everything that we know of in the case against Kohberger. And when we look up here, just like he said, oh, they turned it over on January 9th. Well, you see right here, January the 9th, that is defendant's discovery deadline. So that was the deadline for them to turn that over. They didn't turn it over because they're trying to make a deal and get the death penalty taken off the table by Kohberger pleading guilty. Moron, that was the date the judge gave them to turn that stuff over. And the judge was for unsealing that document to start all you monkeys speculating that BS. So that's what the public gets, and that's what these other morons on YouTube that'll listen to somebody like that and go, oh, you know what, I think Kohberger could be trying to, make a deal. No, morons, if you would dive in and actually learn some things about the case, then you would actually know that that was the deadline, and that means absolutely nothing, and that guy knows absolutely nothing. So I mean, he should just, talk about what he knows about and probably not make any predictions because he isn't looking at it close enough to make an accurate prediction. And when you put attorney in front of your name and you start making predictions, well, people will listen to you. Unfortunately, other than Andrew Myers, I'm yet to see an attorney on this case, Yoli. Yoli does a good job, but other than Andrew and Yoli, I've yet to see an attorney on this case that can look at it objectively and not strictly as an attorney. But that's number one. Now, number two is all those terabytes of information. What could they be? We know a lot of it's video, a lot of it's documents, but what is the percentage? They told us in a hearing a while back. Now they told us when it was 51 terabytes. Now, obviously, they've received another 17 terabytes since then, but we can only guess what the other 17 they received are, but I can tell you without a shadow of a doubt what the first 51 were.
So Ms. Taylor's correct. She has everything that the state has in our possession. And we have worked diligently and consistently in getting her all the information that we have in a quick fashion. To date, we have discovered approximately about 13,000 pages of reports, 13,000 photographs, over 10,000 tips, and over 51 terabytes of audio and video information. And over 51 terabytes of audio and video information. And over 51 terabytes of audio and video information.
So I hope that clears up some confusion. They're not trying to make a deal. They're absolutely wanting to take this thing to trial, and they have one heck of a plan for trial, let me tell you. And as I uncover what their plan really is and their strategy really is, it could be a super strategy. Let me tell you this. In fact, I am going to pass it along if they haven't already thought about it. The investigators for Kohberger are insanely amazing. I promise you. They have uncovered more stuff. People always say, send it to the defense, send it to the defense. Most of the stuff that I figure out, I'm figuring out because I'm following what I'm finding the defense doing in this case. Now, there are some things that I do need to send to the defense, and I always say this one needs to go to the defense before I do the video. One thing that I realized, and I said this in a video several months back, there was a phone dump in the King Road neighborhood from 3 a.m. to 5 a.m. It was basically an unconstitutional search of everybody's phone in the area. I've mentioned before, it usually requires a FISA warrant, but somehow they did it. They unmasked all the phones in the area from 3 to 5. We know that because it says it in the PCA and it says Kohberger wasn't one of those phones. But everybody else in that area was one of those phones. So I said in the past, Kohberger investigators, at 4:59, you know you got a guy coming out, getting on his phone, texting his ride to come pick him up, and that is one of the assailants in the case. We were certain of that. So all you got to do is find 4:59, whoever's on that phone right there, and you know you got a suspect. Well, the other suspect that I did in a video the other day that gets out, racks his gun, and then heads towards the King Road residence at 3:50, and then comes back to his vehicle at 4:23. I mean, that right there is your prime suspect, because he's heading there right before and coming back right after. He racks a gun before he does it, but what else does he do? He gets on his phone, we heard him, at exactly 3:49 a.m. and calls the people in the car for the coast to get the coast as clear. So you got that phone dump. All you have to do is match up exactly 3:49 with that phone that was talking to the other phone, and you got two suspects right there. If you haven't already done it, y'all need to do it. That does need to get to the defense. Please like and subscribe to the channel. Post your comments, thoughts, criticisms. Until next time, Pavarotti's out.
Fly away. It's the first time of today.